Bebery O, Santos-Macabata vs. Flaviano Macabata, Jr. GR number 237524, April 6, 2022. Doctrine. The court in Tan-Andal emphasized that there is a presumption of validity of marriage, and that such presumption can only be rebutted by clear and convincing evidence. In the Tan-Andal case, the court categorically abandoned the requirement that psychological incapacity must be medically or clinically identified and proven through expert opinion, as the term psychological incapacity does not refer to a mental incapacity or a personality disorder. Reiterating this court's pronouncement in Marcos v. Marcos, the medical examination by an expert of the spouse concerned is no longer required, as courts may rely on the totality of evidence to sustain a finding of psychological incapacity. The case of Tan-Andal clarifies that the psychological incapacity contemplated in Article 36 of the Family Code is incurable, not in the medical, but the legal sense, and that the requirement of incurability means that the incapacity is so enduring and persistent with respect to a specific partner, and contemplates a situation where the couple's respective personality structures are so incompatible and antagonistic that the only result of the union would be inevitable and irreparable breakdown of marriage. The term psychological incapacity under Article 36 of the Family Code is characterized by 1. Gravity, which entails that such psychological incapacity must be so grave or serious, such that the party would be incapable of carrying out the ordinary duties required in marriage. 2. Juridical antecedence, that psychological incapacity must be rooted in the history of the party antedating the marriage, although the overt manifestations may emerge only after the marriage. And 3. Incurability, or, even if it were otherwise indeed curable, the cure would be beyond the means of the party involved. Facts. Sometime in October 1996, petitioner and respondent were working as factory workers in separate electronic companies in Taiwan. Courtship and dating followed shortly after they were introduced to each other. Later on, they learned that petitioner was pregnant with their first child. After the termination of their employment contracts in Taiwan, they returned to the Philippines and got married. The couple moved to a rented house in Caloocan City and soon welcomed their first child, followed by their second child. The couple initially enjoyed a peaceful marriage, but eventually the couple began to quarrel, encountering difficulties in supporting their family. The couple moved to the house of petitioner's parents. In February 2000, respondent eventually found work as an entertainer in Japan. Petitioner was shocked to learn that respondent indicated his civil status as single in his passport. Respondent would then proceed to work in Japan and send money to petitioner. Sometime in June 2002, respondent failed to send money to petitioner and ultimately ceased all contact with his family. After 2 years of no communication with respondent, petitioner was able to talk to respondent after he called his sister to tell petitioner that he was no longer coming back to her, and that he was already living with another woman. Respondent told her,
"Wag mo na akong hintayin pa at di na ako uuwi dahil may babae na ako dito. Kung gusto mo, mag-asawa ka na rin."
Agreed, petitioner filed before the II.C. a petition for nullity of her marriage to respondent on the ground of the latter's psychological incapacity. Respondent did not file any responsive pleading. OSG entered its appearance, conduct its investigation, and confirm therein that no collusion exists between the parties. Petitioner submitted as evidence, among others, a report on the psychological condition of petitioner and respondent, report conducted by clinical psychologist Dr. H. Nediel Tayeg. Dr. Tayeg concluded in her report that respondent suffered from antisocial personality disorder stemming from his childhood years, and being afflicted with said disorder, respondent lacked depth when it concerned his marital duties and obligations. RTC granted the petition declaring the marriage of the parties null and void ab initio, and held that the petitioner provided sufficient evidence to prove that respondent is psychologically incapacitated to perform his marital obligations. OSG filed an MR asserted that the petitioner failed to satisfactorily discharge the burden of proving that respondent was truly incapable of complying with his marital obligations due to a serious form of psychological disorder. CA reversed the RTC decision and held that the RTC erred in declaring the marriage of the parties null and void, considering that the totality of the evidence presented is insufficient to establish respondent's psychological incapacity to fulfill his marital obligations. The CA found that Dr. Tyaig's report failed to fully explain the symptoms of the antisocial personality disorder and establish a link between respondent's acts to respondent's alleged psychological incapacity to comply with his marital obligations. Petitioner filed an MR, which was denied. Issue: whether or not the CA erred when it reversed the decision of the RTC and issued a decision finding that petitioner failed to provide sufficient evidence that respondent is psychologically incapacitated to perform his marital obligations. Ruling: No, the CA did not err in finding that petitioner failed to provide sufficient evidence that respondent is psychologically incapacitated to perform his marital obligations. The court finds that the petitioner failed to prove and substantiate by clear and convincing evidence that respondent suffers from such psychological incapacity that prevents him from complying with his marital obligations as contemplated under Article 36 of the Family Code. Indeed, the respondent has clearly failed to fulfill his essential obligations to his wife and children when he abandoned his family. However, the totality of evidence does not show that such failure to fulfill his essential marital obligations is caused by a genuinely serious and incurable psychic cause which exists prior to or at the time of celebration of the marriage of the parties. From the foregoing, it is apparent that there are inconsistencies in the information provided in the report, and the conclusion of the clinical psychologist therein. A thorough reading of the report would show that the conclusion therein is grounded on general observations nitpicked from certain aspects of respondent's life and based primarily on petitioner's assessment of his upbringing, none of which are fully supported by the information provided by respondent's younger brother who grew up with the respondent. Hence, there is doubt as to whether the report is sufficient evidence to show that the acts of respondent are manifestations of a certain form of psychological incapacity, and that the alleged psychological incapacity of the respondent exists prior to, or at the time of, celebration of the marriage of the parties. For failure to show by clear and convincing evidence that the respondent is incapable of fulfilling his essential marital obligations due to a genuinely serious and incurable psychic cause which exists prior to or at the time of celebration of the marriage of the parties, the court is compelled to deny the petition.